But Mr. Datar, with all of these safeguards in place, there still seems to be a sense that over the years and the decades, whether it is the central government, whether it is the state governments, whether it is district magistrates, there's still a feeling that the rights of individuals, fundamental rights, basic freedoms can and often are trampled upon. We've heard of people being in jail for years altogether without getting a trial. Look at the number of under trials who are there. The entire question of bail. Some people are given bail, some people are not. They're denied bail and they're kept in prison forever. So, despite whatever may have been said on the basic structure in Kesavananda Bharati, it does appear that governments often still can find a way to trample on individual rights, basic structure or no basic structure. How can that be dealt with?
No, you see, now the point is the basic structure is part of the constitution, what parliament can do. Basic structure basically says it's a restriction or a, like, let's say it's a dike, right? It's a barrier on what parliament can do. Now, suppose, for example, a person doesn't get bail. Now, that is the fault of the Indian Penal Code, the CRPC and so on, that the person, now why are there, out of 6 lakh people, some 80% are under trials. Why should a person be under trial? Because he can't furnish a bail bond. Then you'll have to have a condition where Supreme Court can say the offence is petty, then there's no need for a bail bond. So that can be done by the judiciary. Now, the fact that people are in jail or freedoms are trampled upon may be something which the judiciary has to address and the legislature has to address. Why do you have wide powers of arrest? Why do you have a UAPA law which says that I can't get bail until I can show that I've got a very good chance of success? Now, this law would have been struck down. Unfortunately, Supreme Court upheld it in some laws. So that I think we can use basic structure to strike down these laws also. In my opinion, the judiciary can go a few steps further and say, no, this can't be done. It's a shock that, as you rightly put it, there are 5 lakh under trials languishing for no reason, and most of them are very poor and marginalized people. That's the sad state of affairs. There's nobody to give a bail bond, nobody to stand surety.
So at the end of the day, you still believe that 50 years later, that judgment that was passed in 1973 with that wafer thin margin is today the biggest and the greatest shield that Indian democracy potentially has to protect itself from something that could turn us into an autocracy at some stage.
Yes, and it is a shield, it's a bulwark, it's a complete protection that tomorrow, even if a government has 90% majority in parliament, they still cannot take away our basic rights. Even if they've got 99% majority, they can't still take it away.
And of course, if that verdict had gone the other way, what do you feel? Would we have still been a democracy today in the full sense of the word, or somewhere along the way, could some of our freedoms have been eroded?
Actually, in my article in the Indian Express today, when the review came up, they wanted to review the basic structure. So apart then this whole thing came that nobody asked for a review, Then Justice Beg said, see, basic structure is not defined. I don't know what's the basic structure. So should we not have the review so that we can finalize it? So Palkhiya responds saying that, he says, I never thought that we'll come to a stage where the Supreme Court can't understand its own judgment. We all know what is basic structure. And then, in the final, Murtaza Fazal Ali, in the review says, why are you opposing the review? Suppose you had lost Kesavananda Bharati. And if you had asked for a review, will the union be justified in opposing it? Suppose you had lost Kesavananda Bharati, would you not ask for a review? Today, government has lost, they're asking for a review, so what's wrong? And Palkhiwala's reply is extremely important. He says, and I'll quote his exact words, he says, without a trace of flippancy, my lord, if we had lost Kesavananda Bharati, there would be no Supreme Court before which I could argue.
Arvind Datar, thank you so much for joining us on why that was such an important judgment 50 years ago. Thank you so much for being with us.